Test, test. Test, test. Test, 1, 2. One, two. Test, 1, 2.
Good morning. The Judiciary Committee will come to order. Without objection, the chair is authorized to declare recesses of committee at any time. We welcome everyone to this morning's hearing on oversight of the Executive Office for Immigration Review. And uncharacteristically, I'm not going to begin by recognizing myself for an opening statement. I am going to introduce our witness and say welcome to him and ask if he would please rise so I can administer an oath, and then I will properly introduce you. Do you swear the testimony you're about to give is the truth, the whole truth, nothing but the truth, so help you God? May the record reflect that the witness answered in the affirmative. This morning's witness is Mr. Juan Osuna, who was appointed as the Director of the Executive Office of Immigration Review in May of 2011. Served as acting director from December 2010 to May 2011. Prior to that, Mr. Osuna was at the Department of Justice as an Associate Deputy Attorney General from May of 2009 until June of 2010. He was a Deputy Assistant Attorney General in the Civil Division, Office of Immigration Litigation from September of 2008 until May of 2009. He served as Chairman of the Board of Immigration Appeals. He also served as Acting Chairman and Acting Vice Chairman. He holds a Bachelor of Arts from George Washington University, a law degree from the Washington College of Law at American University, and a Master of Arts degree in Law and International Affairs from American University School of International Service. Mr. Osuna, we welcome you. Things will be a little bit different this morning, given the nature of the day, and I know that my colleagues on both sides want to be here, and many of them will come, but they may come at unusual times. So we're going to recognize you for your opening statement first, and then the members will do their opening statements, and then we'll go to questioning.
Thank you, Mr. Chairman. Mr. Chairman, Representative Lofgren, and other members of the subcommittee, thank you for the opportunity to speak with you today about the Department of Justice's Executive Office for Immigration Review, or EOIR. EOIR's role in the removal process is to hear the cases of individuals charged with violating our immigration laws and to decide which of those individuals should be removed from the United States and which are eligible for relief or protection from removal. The agency carries this mission out through our core of 250 immigration judges in 58 courts around the country and our appellate tribunal, the Board of Immigration Appeals. Each of our cases begins when the Department of Homeland Security files a charging document with one of our immigration courts. Among the many challenges facing the immigration courts, the largest is our growing pending caseload. There are more than 450,000 cases pending in immigration courts around the country. This is an all-time high. This backlog grew in recent years due to budget cuts when the agency was severely limited in hiring immigration judges and staff to replace those who left the agency. While the immigration judge corps was shrinking, enforcement continued, and the courts would continue to receive new cases, resulting in continuously increasing caseloads. This was exacerbated by the border influx that began in the summer of last year. From July 2014, the time EOIR started tracking these southwest border crossers, until September 30th, 2015, more than 100,000 cases have been filed in the immigration courts nationwide. We are taking steps to increase our capacity to adjudicate cases through a vigorous hiring effort, and hiring immigration judges is my first priority. I am pleased to report significant progress on this front and greatly appreciate Congress's support for our efforts by providing the funding necessary to augment our judge corps. Over the past year, 23 new immigration judges have entered on duty, and as of this week, the Attorney General had selected another 37 individuals to serve as immigration judges after a thorough and rigorous hiring process at EOIR and within the department. These individuals are now undergoing the required background and security checks before they can start hearing cases. Many more immigration judge candidates are going through the final stages of the review process at the department before they can be recommended to the Attorney General for selection. These new judges will be arriving in immigration courts throughout the country in the coming months, and it will have a very, very positive effect on the pending caseloads, enabling the courts to begin to correct the imbalance between the incoming caseload and the number of judges available to adjudicate it. Again, thank you for your support for these much-needed resources. Within the immigration court system, certain cases are prioritized for adjudication. Those cases involving individuals detained by the Department of Homeland Security have traditionally been the agency's highest priority. Not only do these cases often involve individuals convicted of serious crimes, but they also implicate the individual's liberty interests. In July of 2014, EOIR added the cases of unaccompanied children and families who were not detained to its existing priority caseload. This prioritization was in direct response to the administration's effort in the summer of 2014 and beyond to address the factors that brought a high number of people across the Texas border. EOIR is processing these cases as quickly as possible, consistent with due process. I want to touch on a few other initiatives that, in addition to the hiring of new judges and staff, will help EOIR improve the efficiency and effectiveness of the court system. First, deployment of new video teleconferencing equipment into the immigration courts is nearly complete. These VTC units are important because they are a force multiplier, allowing immigration judges to conduct hearings remotely, thereby allowing them to save on travel costs and time and simply to do more cases. By February, every immigration courtroom in the country will have a new VTC unit. We are taking steps to enhance accessibility to the court system while increasing efficiency and combating fraud. EOIR heads a departmental working group designed to fight notarios and other unscrupulous practitioners who undermine the integrity of the system. The group's efforts have had a tangible positive effect, including assisting in the prosecution of a number of fraudsters and notarios around the country over the last few years. While we help put unscrupulous practitioners out of business, it is important that we also make it easier for legitimate service providers to step in. On October 1st, we published 3 regulations designed to make it easier for legal services to reach individuals who are in removal proceedings, including many detained individuals. We expect that these programs will help improve the quality of representation in immigration court. Finally, EOIR continues to expand its highly successful legal access program. This program, which is now active in 37 sites around the country, helps the court process function more efficiently and effectively while providing information to people facing removal. Mr. Chairman, Representative Lofgren, these are some of the initiatives that we have underway. They are positioning us well for the agency to have a very positive 2016. Thank you, and I'm pleased to answer any questions.
Thank you, Director. I'm going to recognize myself for an opening, and then when my colleagues from California and Michigan get here, we'll recognize them. But we may go to questioning from the gentleman from Iowa and Texas before then. We're going to try to make it all work and be good stewards of your time in the process. Within the Department of Justice, the Executive Office for Immigration Review is charged with overseeing the immigration courts and the Board of Immigration Appeals, which is the highest administrative authority for interpreting immigration laws. As the delegates of the Attorney General, immigration judges serve an important function in the administration of our immigration system. They award asylum to those fleeing persecution. They grant deserving aliens the privilege of permanently residing in the United States. And they also order remove those aliens who have violated our laws and abused the generosity of this nation. Whether our law requires immigrants to return to their native land or whether it affords them an opportunity to stay in this country would depend upon the ability of the immigration judges to faithfully apply the law that Congress enacted to their cases and to exercise their impartial judgment unhindered by political agenda. Because of the relative obscurity of immigration courts, their labors largely go unnoticed and you could argue unappreciated by the American public. But their decisions affect real people, the immigrants and their family members alike, and their effect on the immigration system is critical. Everyone, those who stand before the administration judges, this administration, and our fellow citizens, has a vital interest in ensuring justice in our immigration courts is dispensed fairly, efficiently, and expeditiously. That is one reason I am troubled that there are approximately 460,000 cases waiting for an immigration judge to make a decision. In addition, I remain troubled by allegations of abuse, fraud in the asylum program. Abuse and fraud, frankly, hurt everyone, those legitimately entitled to relief and those who depend upon a fair justice system. The average alien will wait nearly 3 years before the judge renders a decision, and those are the fortunate ones. According to the 2012 DOJ Inspector General report, over 21,000 cases were pending 5 years or more, and over 6,200 cases were pending for 10 years or more. The real effect of these delays is to penalize those awaiting relief based on a valid claim to immigration benefits and reward those who have no right to remain in the United States with many years of continued unlawful presence. Testimony before the Senate earlier this year indicated the backlog had increased 100% over the last 5 years, and the answer to the problem was alleged to be more immigration judges. But the DOJ Inspector General found from fiscal year 2006 to 2010, while the number of immigration judges increased, case completions actually decreased. So the Office of Inspector General found inefficiencies persisted despite the addition of more immigration judges. The Inspector General also noted incomplete or exaggerated performance reports and noted the absence of the data or an objective staffing model to guide its resource planning and deployment of immigration judges, which begs the question as to whether or not additional immigration judges alone will solve the problem or if something else is required. Additionally, a report by the Government Accountability Office released yesterday found derelictions in implementing the necessary policies and procedures to address asylum fraud. Lack of focus on rooting out fraud in the asylum program, coupled with a backlog that allows people to stay in the country unlawfully through the long backlog of cases until their court date, is a gap in our national security. The bottom line is an inefficient and flawed adjudication process further diminishes our capacity as a nation to effectively deal with our broken immigration system. And for that reason and others, I look forward to today's questions and answers. Again, I will recognize Ms. Lofgren and Mr. Conyers whenever they come, but I will begin by recognizing the gentleman from the great state of Texas for his questions, the former United States Attorney, Mr. Ratcliffe.
Thank you, Mr. Chairman, for holding this hearing. Thank you, Director Osuna, for being here today. You know, the 700,000 Texans that I represent are certainly concerned about the impacts of illegal immigration in this country and what many see as an environment of lawlessness created by this administration when it comes to the enforcement of our immigration laws and, frankly, the inefficiency of our immigration system. And one of the things that highlights that is a fact that was related by the chairman, the fact that there are approximately 459,000 immigration cases waiting for action right now. And, you know, it would appear that that type of backlog of cases really amounts to de facto amnesty because it allows individuals that are in this country, perhaps illegally, to remain here without any repercussion as their cases are stuck in administrative limbo. So I'm anxious to hear some of your testimony today about your plans to reduce that backlog. One of the cases that I want to ask you about in terms of contributing to a backlog is one of the judges in the Houston Immigration Court, Judge Mimi Yam. Are you familiar with Judge Yam?
Yes.
All right. Over the past 5 years, there were a total of 24 months in which Judge Yam failed to issue a single ruling. Were you aware of that?
Not to those specifics, but I'm aware of the issues there.
And why don't you relate for us what the issues are there?
Congressman, what I can tell you is that that particular judge is not hearing cases at the moment. It is an unfortunate personnel issue that I can't get into with you in this forum, but it is true that she is not hearing cases at this time.
Well, whether she's hearing cases at this time or not, she's been paid as an employee of the United States government, and there have been long periods where, while she's being paid to do that, she's been hearing cases but not ruling on cases. And to highlight that fact, she went as long as 7 months without issuing a single decision, and through May of this year, she's issued a total of, I think, 15 decisions, where over the same period of time, one of the judges right next door to her issued decisions in 700 cases. Can you see why in an oversight hearing like this, the American people would be concerned about this type of inefficiency when it comes to ruling on our immigration cases?
Congressman, again, because I can't get into the personnel issues, we can't get into the specifics here. What I can tell you, though, is that Houston is actually one of the courts that we have targeted for adding a significant number of new judges as part of the hiring that we are currently doing. As I mentioned in my opening statement, we have added 23 new judges over the past year. The Attorney General, as of this week, had selected another 37, and we are in the process of hiring quite a few more. Houston is one of the immigration court locations, one of the immigration courts that we are targeting for more judges because of the great need there.
So, Director, we've the backlog of cases is clearly well documented. I understand that your office has shifted many of its resources to address the cases who crossed our southern border primarily on or after May 1, 2014. Would it be fair to say that the docket is primarily devoted to hearing cases involving minors and family units who were apprehended at the U.S. southern border as part of the surge?
Congressman, those cases are a priority for us, along with the cases of detained individuals. And for the reasons that I said it earlier, detained individuals are often the ones that have committed serious crimes in this country. Therefore, we move those to the top of the priority list. We make the judges and staff available to hear those cases first before all others. You are correct that last year we also added to the priority list the cases of unaccompanied children and families and others that were crossing the southern border as part of our response to the influx. I would say that a great number of the adjudications in our courts are of those two large groups. It does not mean that we don't adjudicate other non-detained cases that are pending in immigration courts around the country. We have to draw this line between making sure that those priority cases are taken care of first, but also not neglecting those cases of others that have been waiting for a long time for their hearings.
So I want to ask you about the timing in the a few seconds left here. Director, do you think it would be fair for me to say that there are presently thousands of unlawful aliens who won't have a hearing before an immigration judge for perhaps the next 5 or 6 years?
There are thousands of individuals that are waiting for their hearings. We prioritize those who need to have their hearings first because of compelling national interests, such as the need to get detained cases heard first and adjudicated first and get criminal aliens out of the country, or those who crossed the border last year. But there are others that are going to have to wait for their hearings that are because of the prioritization.
And because of that prioritization, as you've encapsulated for us, in some cases right now that's 5 or 6 years.
In some immigration courts, the wait can be as long as 5 years, yes.
Mr. Chairman, I see my time's expired. I yield back.
Gentleman from Texas yields back. Chair will now recognize the gentlelady from the great state of Texas, Ms. Jackson Lee.
Thank you very much, Mr. Director, and thank you for your service. I'd like to explore a line of questioning because I think it's important to discern the responsibilities of your office versus the State Department and how we can be helpful, the Congress and particularly this committee. Let me follow the line of questioning of my colleague from Texas regarding the lengthy backlog and to cite again the 450,000 cases of which are backlogged and an individual on the non-detained immigration docket might have to wait up to 4 years. Certainly, I am from the Southern District of Texas, and I know the immigration courts there. This delay means that people with potential claims for immigration relief remain in limbo throughout the pendency of their immigration court process. This affects vulnerable populations such as children, asylum seekers, and other immigrants hoping to obtain immigration relief, and they are in the legal system because they're trying to go into court. What solutions do you propose to resolve the staggering immigration court backlog, and how can members of Congress in particular help the EOIR office? And I have a series of questions. I'm going to let you briefly answer those, but I'd like to go into some other questions.
Thank you, Congresswoman. Our main approach to making sure that we have this balance between the incoming caseload and the adjudicators is more immigration judges. We got into this situation because of a number of years where there were severe immigration judge shortages. We lost a number of judges from 2011 to last year during a time of budget cuts. We were not able to replace those judges who left the agency.
And you have a capacity for how many?
We currently have, thanks to Congress's appropriations for us this past year, we have 319 authorized positions. We are filling those as quickly as we can. Those judges will make a significant impact.
So why don't you help us out? You have 319, but you're at a smaller number right now. Is that correct? You have 250 judges.
That's correct.
And I think you have some good news about those that have been approved. How many have been approved to be added to that?
That's correct, Congresswoman. In my opening statement, I mentioned that we have added 23 over the past year, and the Attorney General has approved 37 more as of this week, and several dozen more are in the final stages of the selection process at the Department.
And the President's asked that you mention that in your opening statement as well.
The President has asked for another 55 immigration judges for fiscal year 16, and that's going to be a very significant step forward for us as well, and we ask for your support for that.
And that will make a sizable difference as well.
That will get us to about 384 immigration judges nationwide when all of those positions are filled, if Congress provides those positions. That is going to have a very, very significant impact and will enable us to begin to shorten these wait times in the most backlog courts.
And I would imagine, though we're not getting to personnel matters, you're going to ferret, sort of review your immigration judges to make sure that they are both hearing cases and ruling. I think that's an important oversight as well. Will you engage in that?
Exactly. So the process that we have for selecting immigration judges is designed to make sure that we select the best candidates that are representing the Attorney General in these courtrooms.
Let me move to a situation I think should be clear. First of all, refugees coming into the country are handled by the State Department. But if I was online, one of those cases, and I was seeking asylum, we know that you will have a hearing before the immigration judge. But that is not the final decision. Would you explain, after that hearing before the immigration judge, what process goes forward to ensure that that person is not a national security threat?
Immigration judges are prohibited by law from actually granting asylum before, unless that person is then sent for background and security checks by the Department of Homeland Security. So if an immigration judge finds that somebody is legally eligible for asylum and merits asylum in this country, that judge then has to suspend the case, more or less, send the case to the Department of Homeland Security for the required background and security checks. Those security checks are done with the FBI and through the interagency database check process. And only until that case comes back and DHS tells the judge the background is clear, this person is not a danger, can the judge go ahead and grant asylum.
So there are layers that are added to a judge's original hearing that add to our security. Let me quickly ask this question. Does your agency have a plan for addressing concerns about the expedited review of prioritized cases, such as those involving children and those who are detained criminally? And would you like to highlight the new policy change that I understand that you may be suggesting from 21 days to 90 days?
For detained cases, we don't have a policy change. We're doing what we've always done on those. We're prioritizing those cases. We do have a change on the unaccompanied minor front. We have been, our commitment beginning last year was to hold those cases, those hearings, initially within 21 days of the case being filed in court. In consultation with our federal partners and after hearing from a lot of stakeholders over the last few months, we've been considering a change. So we have decided to move that timeline, adjust that timeline from 21 days, from 10 to 21 days to 30 to 90 days.
Is that for the unaccompanied children?
For unaccompanied children.
Not impacting criminal individuals.
That's correct.
And I think that's important to clarify. You're doing that because stakeholders found it's kind of complicated to get all the facts together for the children?
That's right. I mean, we feel that this change will provide our courts with more flexibility for these challenging cases, but also it will provide the children more time to find legal counsel, and that works to the efficiency of the immigration courts. It actually helps us in the long run to move these cases faster by actually providing more time initially for the kids to get counsel.
I think all of us would appreciate, thank you, Mr. Chairman, I'll finish on this note. I think all of us would appreciate that children are vulnerable and children do need more legal protection and more time. And it's not where the children are not within the purview of the courts or HHS in the instance of their detaining, but it is to give them more rights so that the decisions can be more adequate as to the ultimate resolution. Would that be the correct assumption?
We're making the change because it helps the efficiency of our courts, and it helps by helping the kids, giving the kids more time to find counsel. It actually helps the court function more efficiently. That's correct.
With that, Mr. Chairman, I yield back. Thank you.
General Lee's time has expired. She yields back. The chair will now recognize the gentleman from Iowa, Mr. King.
Thank you, Mr. Chairman. Director Osuna, I appreciate your testimony and the fact that you're here. We've watched this grow over the years. It's not a big surprise to me to see these numbers grow the way they have. But I wonder if you can break this down for us a little bit. I'm looking at numbers in your testimony that say that there's a 457,106 case I'll call it a backlog case, and that it has increased more than 298,171 since 2011. From that, I can't exactly determine whether that's those, if I can match up fiscal years, but could you tell me roughly how many additional cases have accrued on an annual basis over the last 4 or 5 years?
I don't know if I have those numbers exactly, Congressman. What I can tell you is over the we started tracking, for example, the southwest border crossing cases beginning last summer, and I can tell you that we have added 100,000 cases have been added to the court dockets from the summer of 2014 through this fall, primarily through the border.
Okay, so if I average those numbers, that's about 75,000 a year. So if it's 100,000 that's been added over roughly the last year that you can contribute, that then is an accelerating number, but probably more than an acceleration of 25,000 additional a year. You know, I'll just say I've been down to, I don't want to put words in your mouth, that's just my math. So, but I've been down to the border a good number of times. I recall standing on the banks of the Rio Grande River at Roma, Texas, with my video camera, a couple of Border Patrol agents, and watching as 2 coyotes drove around on the other side of the river until a shift change took place. And then they pulled their inflatable raft out of the trunk of their car, inflated it. 2 coyotes helped loaded a pregnant lady in that raft and came across the river, docked the river in the weeds on the, docked the raft in the weeds on the U.S. side of the river, helped her out, handed her 2 little bags of her possessions. She patiently stood there for the shift change to be complete so a Border Patrol agent could come along, pick her up. One could expect that she applied for asylum. Seems to me that it's not that they fear enforcement, nor do they fear adjudication. They seem to welcome that. And so what is the percentage of asylum applicants that are granted asylum that are coming across our southern border, especially in the McAllen region?
Congressman, that's a tough number to get, and I'll explain why. Because if the border crosser is an unaccompanied child, the law provides that individual's asylum claim, if they file one, actually has to be heard by USCIS at DHS. So the child comes to immigration court first. The judge does what he's going to do with that case in terms of hearing the pleadings. If the child then wishes to apply for asylum, the judge then has to send that case over to USCIS. Many of those cases are still pending at USCIS, is my understanding, and I don't have a firm number as to how many of those are being granted.
But you could actually go down through those records now and draw from those records the status of each one of them, put that in a spreadsheet, and let this Congress know the status of these asylum claims by children that you've selected from the question I asked. It could be done, could it?
I don't know if it can be done. We're certainly happy to look into it.
I would ask you, into the record here, if you would produce those records, not only for the children that apply for asylum, for all the asylees that apply. I'd like to see the results of that, the adjudication process, where it is, how many are pending, why. I'd like to see and I'll put this in a formal letter so that it's clear, and I won't ask you to remember all this, but I'd like to see the effect of the continuances that have been offered. And the data I'm looking at continuances are the OIG's report, 953 cases reviewed by the OIG, 4,091 continuances offered or allowed for 953 cases, totaling 375,047 days in the aggregate. So it averages 92 days per continuance and 368 days per case. So every case that is an asylum application by this GAO report results in more than a year of continuances. Have you looked at how to compress that so that we can get that adjudicated in a quick fashion? As we know that if we don't send them back, those that need to go back, they're going to keep coming.
On the issue of continuances, Congressman, we have looked at that. The continuances are actually a legal matter that is governed by the regulations. The standard under the regulations are that immigration judges are to grant a continuance if there is good cause shown. And there is much case law from the BIA and from the federal courts as to what is good cause.
Of course, I'm out of time, but I would just say that the good cause is be unlikely to be 4 different good causes in a row on average for each case lasting a year. I'd conclude my questioning. I thank you for testifying, and I yield back the balance of my time.
Thank the gentleman from from Iowa, excuse me. The chair would now recognize the gentleman from Michigan, Mr. Conyers.
Thank you, Mr. Chairman, and I thank my colleague, Ms. Lofgren, for letting me go in front of her.
Mr. Chairman, can I just,
I yield.
Mr. Chairman, could I put these in the record before you go forward? Thank you for your kindness. I have a meeting. I would like to add to the record, unanimous consent, Mr. Chair, a statement from the American Immigration Council, underfunding of immigration courts undermines justice, and a second document, Executive Office for Immigration Review, Unaccompanied Children Priority Code Adjudication. Ask unanimous consent to put these items into the record.
Without objection.
Thank you.
You're more than welcome. I ask unanimous consent to put my opening statement in the record, Mr. Chairman.
Without objection.
And we find that there's a problem that our immigration judges, well, when it comes to immigrants, we sometimes confuse judicial discretion with judicial abuse. And I think you're very sensitive to that, Director Osuna. Too much of our proposals legislatively have sought to streamline the immigration court removal process by taking discretion out of the hands of the immigration court. And so some believe that many forms of relief granted to immigrants are without merit. And I'm not sure if that's the case. Do you have a view on that, sir, that you could relate to us?
Congressman, on the issue of merit of claims, that's what our judges are there for, to determine which cases are actually meritorious and which are not. And they do a great job of that every day in immigration courts around the country. On the issue of discretion, again, I trust our judges to exercise discretion in the best way possible, and we believe that that is appropriate to vest them with that authority.
Thank you. I tend to agree with you, and I realize that this is a thankless task to ensure that immigrants in removal proceedings have a full and fair hearing before an impartial immigration judge. And so it's in that spirit that I come to these hearings, and you know, the delay in hiring immigration judges is often cited as a reason for the immigration court backlog. What are the challenges that you might give us this morning with reference to the hiring of immigration judges?
Congressman, we have a very robust and multi-layered process for hiring immigration judges. It takes a long time, but we feel that it is necessary to do this carefully, because these individuals, as you know, are exercising the Attorney General's authority in immigration courtrooms around the country every single day. They are literally making life and death decisions, so we need to make sure that we are selecting the best candidates to serve as immigration judges. That requires multiple layers of review at UIR and at the department, and careful vetting to make sure that we are getting the best of the best. That unfortunately takes some time. We have been able to streamline the process to some extent over the last few months to make it go a little bit faster, but we think that the process actually helps to make sure that we select the best individuals. Mm-hmm. In my opening statement, I did mention that we have added 23 new judges over the past year, and the Attorney General has selected 37 new judges as of this week, who are now going through the required background and security checks before they begin hearing cases. So we are adding judges as quickly as we can and selecting good people, and they will make a significant difference.
In your testimony, finally, you include a chart on immigration judge hiring. And in the second quarter of 2015, where you did not hire any immigration judges, can you explain why EOIR did not hire any during that period?
There were judges in process at that time. What the chart shows is the actual number of people entering on duty. In other words, judges entering on duty within that particular quarter. So the hiring process was going on during that second quarter. They just had not entered on duty as of that time. You'll see that the third quarter shows 18 new judges entering on duty. Those were the ones that were in process in the prior 2 quarters.
Mm-hmm. Thank you, sir, and I thank the chairman.
Chair would now recognize the gentleman from Colorado.
Thank you, Mr. Chairman. I yield my time to the gentleman from Texas.
Gentleman from Texas is recognized.
Thank you, Mr. Chairman. Thank the gentleman from Colorado for yielding his time so I could follow up on a question, Director Osuna, that I didn't have time to ask in my prior line of questioning, and that is this. What is the official policy for granting a continuance in an immigration case?
Continuances are governed by regulation, Congressman. The regulations provide that a judge may grant a continuance for good cause. And that good cause standard has been filled out, has been outlined and defined through court decisions over a number of years. So that is the standard. Immigration judges refer to that standard, follow the circuit law and the BIA law on what is good cause, and it depends on the individual case.
Okay, so we know that that standard is established by, by case law and precedent. But the Inspector General report from 2012 cited frequent and lengthy continuances as the primary factor in this backlog that we've been talking about of now almost 500,000 cases. You're aware of that fact?
I'm aware of the Inspector General report, yes.
And the fact that they cited that as a primary factor?
I'm aware that they cited it. I can't remember what ranking they gave it, but I do remember that they did cite it.
Okay, well, to that point, the Inspector General actually recommended that your office, and I want to quote this so I make sure I get it right, recommended that your office, quote, analyze the reasons for the continuances and develop guidance that provides immigration judges with standards and guidelines for granting continuances to avoid these unnecessary delays, end quote. You remember that from the IG report?
I remember that.
Okay. Can you tell me what you've done to comply with that recommendation?
Sure. Continuances, again, are governed by legal standards. What we've done is 2 things. Number 1 is that we do provide regular training for judges on continuances. We provided a legal training just a few months ago on a number of issues. And provide information on what the courts have said about that legal standard. Secondly, this is more of a management issue, but our assistant chief judges, which are the supervisory judges that have supervision over particular courts, do monitor the continuance issue and the oldest cases that are pending on court dockets, and they take action as appropriate. Sometimes it is not appropriate to take any action because it is the number of continuances is actually appropriate in the particular case. But where there appears to be something, an outlier issue with somebody granting continuances for, other than the good cause standard, then that is treated as a management issue.
So is this having an impact on the number of continuances?
I don't have an answer for you on that, Congressman.
All right. So then let me ask you this question. If during an immigration case, the Department of Homeland Security provides sufficient evidence to find that an individual in question is not entitled to admission to the United States, what's the role of the immigration judge?
If I understand your question, I think that if the Department of Homeland Security
Finds
somebody is,
not entitled to admission.
well, that's a legal determination that the judge would have to make, but certainly DHS as a party in the courtroom would have a significant impact on that decision. The judge's responsibility is to find that somebody is removable from the country or not removable. If they are removable, the evidence submitted by DHS goes a long way to proving that, because that is DHS's burden.
Well, if the determination is made, the judge's role is actually to sustain the DHS charge of removability. Isn't that right?
The judge's role is to determine whether somebody is removable, and DHS's evidence going to that fact or that legal determination is obviously very relevant, if not determinative, in the immigration judge's decision. That is not the end of the discussion in immigration court, because if a judge finds somebody is removable from the country, then he has to consider, or she has to consider, whether that person is eligible for some sort of relief from removal.
All right. So 121 convicted criminal aliens released by the Obama administration between 2010 and 2014 have been charged with homicide-related crimes. Were you aware of the fact that 33 of those individuals were released on bond at the discretion of your office after committing the original crime?
I'm aware of the 33, yes.
All right. And does that concern you?
Congressman, those cases, immigration judges held bond hearings, as anybody or most people that are not detained mandatorily are entitled to request. The law provides that immigration judges are to determine two things in a bond proceeding. Number one is the personal flight risk. Are they going to show up for their hearings, or are they going to abscond? Number two, and more importantly, are they a danger to the community? Are they a danger to others? If the judge finds that they are a flight risk, he or she may set a high bond or no bond at all. If they are a danger to the community, typically judges don't release them or set a very high bond. They don't release them. So the 33 individuals that you mentioned, I have no reason to think that judges made the wrong decision in those cases.
Did you go back and review those cases?
I'm aware of some of them. I didn't review every single case.
Chairman, I see my time's expired. I yield back.
The gentleman from Texas yields back. The chair will now recognize the ranking member, the gentlelady from California, Ms. Lofgren.
Thank you, Mr. Chairman, and Mr. Zuna. I'm sorry I was late. I was at a meeting also on an immigration matter. I would ask unanimous consent to put my full statement in the record.
Without objection.
I would just note that we have ramped up expenditures on immigration enforcement over the past decade substantially. We have increased the funding for the Border Patrol and for ICE. That's more than quadrupled the expenditures there. But our funding for the immigration courts has lagged far behind. We've had a 70% increase for courts and a quadrupling of expenditures at the border. And I think, you know, no system is perfect. I'm not going to say, having worked as a lawyer in this system many, many years ago, but you can't just keep jamming more into the system. You need to ramp up the capacity in the immigration courts. And we're making some baby steps forward on that now, but I am concerned, given the demographics of the immigration judges, we are facing a tidal wave of retirements among the ranks of immigration judges. Now, those are funded positions, but we're going to have to go out and hire people and train people. So I think we've got a picture that is going to be very problematic to manage. Mr. Ozuna is an old hand at this. He was here during the Bush administration, during the Obama administration. He knows what he's doing, but I'm hoping that he will let this committee know if he needs additional assistance, because it's in everybody's interest that this work well and that the immigration judge system and the court system works well. I just want to mention one other thing, and I know it's not entirely, actually it isn't up to you, but I have continuing concerns, and I raised this issue when the Attorney General was here, about the due process implications of children appearing in immigration court without counsel. I don't see how an 8-year-old who speaks no English can appear without counsel and possibly represent themselves and meet the due process expectations in our Constitution. So I throw that out there. I know that efforts are being made to coordinate with pro bono lawyers, but I think ultimately litigation will resolve this issue for us, and we need to be prepared to respond. If I may, Mr. Chairman, perhaps I could, in addition to doing my opening statement, I can go directly to my questions, and we will be able to expedite the conclusion of this hearing.
Yes, ma'am.
I had a question about the asylum applications in the one-year filing deadline. Because of the backlog, and I think the rocket docket actually aggravated that, because all the resources were put forward and all the other cases ended up being delayed. We've got a problem, and it's my understanding that in August of this last year, Human Rights First and the law firm of Aiken Gump requested an EOR memorandum to instruct immigration judges that administrative delays can constitute an exceptional circumstance to the one-year filing deadline. And I'd like unanimous consent to enter this letter in the record.
Without objection.
Doesn't it seem to me, and doesn't it seem to you, that if the delay is not caused by the applicant, but by the administrative delay in the courts, that shouldn't be an adverse finding for the applicant themselves?
Congresswoman, thank you for your question. I am aware of this issue. I can tell you that we are looking at it, and we have heard from the stakeholders on this issue. I would note that the law does provide some exceptions to the one-year deadline,
Right.
as you know, that judges consider on a case-by-case basis every day. What we do see is respondents filing motions to advance their cases to earlier court hearing times in order to address this issue. So that does happen, but to your point, I understand the issue, we're working on it, and we have heard from the stakeholders on the concerns.
Two other questions. I think when we want speedy resolution of matters, but you can go so fast that you end up causing delay. Mm-hmm. And I'll give you an example of a young person who fled gang violence in Honduras. He got death threats. He fled. He has an asylum case to be heard. He was released from detention. He was placed with a family, but it moved so fast that the notice was sent to where he had been. He never got it. And so by the time he lined up with a pro bono attorney, he'd been ordered removed in absentia, but he never even knew about the hearing. So now there's a motion to reopen the hearing. It causes more work for everyone. And I'm wondering if we've given some thought to how we might ensure that there's actual notice received by people when we've accelerated these cases, not only in terms of fairness for the individuals involved, but also for the system, because you've got to spend a lot of time and effort on the motions to reopen as well that could be resolved.
Thank you, Congresswoman. In a prior discussion with Representative Jackson Lee, I did mention that we have decided to make a change as to the initial timeline. As you recall, last year we committed to holding the first hearing for an unaccompanied child from 10 to 21 days after the case is filed. We have been pondering changing that for the exact reason that you mentioned, that it actually helps court efficiency to actually provide more time at the beginning. So we have decided to change that, and we will be instructing our courts to hold that first hearing from 30 to 90 days after the case is filed, rather than the 21 days. We do strongly think that that will help with a lot of these kids getting counsel and thereby helping the efficiency of the court.
Final question. EOR lags behind other court systems in terms of filing documents electronically. Now, all the federal courts and all the courts in California, you can file your documents electronically. It's a convenience not only to the bar, but it's a convenience for the court. We now have, you still have to get paper filing. I assume that's a resource issue, but what steps can be taken to bring EOR up to modern standards in terms of electronic filing?
Electronic filing is one of the things that I feel strongly that we need to move towards, and we actually have taken some steps on that. We were able to secure some internal funding, I believe it was about 18 months ago, to begin the first step of this, which was electronic registering of attorneys practicing before our immigration courts. That will be one of the foundations for a system that we hope will eventually allow us to file and exchange documents electronically.
Do you have a timeline for that?
I don't have a timeline, but we do have a plan. It's an aggressive plan. I think 2016 we're going to see some progress on that, and we hope that we eventually will get to the point where people will be able to file electronically.
Thank you, Mr. Chairman.
Gentlelady yields back to Chair, will now recognize himself. Director, I wanted to ask you about the Inspector General for the Department of Justice, but my friend from Texas' line of questioning prompted me to want to go a little further there. I'm going way back in time to a period where I wasn't all that knowledgeable even back then, so I'm less knowledgeable now. But if memory serves, the government and the defendant can consent to a bond. It doesn't necessarily have to be adjudicated by a judge, does it? Or is immigration different?
You're talking about a bond, sir?
Bond.
The bond process, what I think happens is that ICE actually makes the first determination on bond when they are detaining an individual. And in some instances, that individual can then request a redetermination by an immigration judge.
Well, you had a line of questions with the former U.S. Attorney in Texas about the 33 who were charged with homicide, I assume. Well, homicide's not a charge in South Carolina. Murder, some form of murder. I'm just wondering whether or not the government consented to bond in any of those cases, or whether or not you've had a chance to look at that.
I believe in the majority of cases, the judge made the determination on bond, and the Department of Homeland Security did not appeal that determination.
All right. In the area of appeal, I think you mentioned the standard for continuance is good cause.
Correct.
Can you cite me to any opinions of record where a judge was reversed for granting a continuance?
I can't cite you any particular cases, but I do know from my experience when I was on the Board of Immigration Appeals many years ago that judges would get reversed for granting too many continuances when the DHS appealed that decision.
Well, good cause is probably hard to define despite the efforts of courts to do so. What would be a reason not to grant a continuance?
It depends on the individual case, but for example, if a judge has granted a couple of continuances already for the individual to get counsel, and the individual has made no reasonable efforts to secure counsel, a judge can very well, and often do, say, you know, I've given you a couple of chances here, it's time to move on, and judges make those decisions every day. That's a fairly frequent occurrence.
Speaking of frequency, is the first continuance fairly much for free? I mean, do you get the first continuance just simply by asking for it?
Again, it depends on the context. In detained cases, it's not that way, and non-detained cases, it can be in some courts, depending on what the situation is.
All right. You mentioned the factors that the court considers in either detaining somebody or setting bond, the flight risk and the danger to the community, which prompts me to want to ask about folks who abscond. What percentage of folks fail to appear for their court date after a bond is set?
I don't have that number for you, Mr. Chairman. Some do fail to appear. The size of the bond is designed to make sure that they appear, but you know, some sometimes don't.
I'm with you, Director. I used to live it, but from where I sit, the number of folks who fail to appear would be a pretty serious issue. I'm assuming you don't trial try them in their absence?
Well, actually, they do. There is a process for if somebody has
You
received.
have to prove they got notice.
If they got notice of the hearing, if
Okay.
the law does provide, and our judges every day hold hearings in absentia. What happens at that hearing is that the Department of Homeland Security comes forward, presents evidence of the individual's removability. The judge considers whether the person got adequate notice. If the answer is yes, then the judge will order an in absentia order, and that order can be enforced by the Department by DHS.
All right. If somebody fails to appear, what is the mechanism by which you compel their appearance? Do judges issue bench warrants?
No, our judges don't have that authority. We don't have anything like the Marshal Service or anything like that. The judge will consider if the person got adequate notice that they will issue the in absentia order if it's appropriate, and then DHS has the responsibility of picking them up and actually removing them.
Of your backlog, what percentage would you say are folks who absconded or failed to appear after a bond was set and a trial date was set?
If they have received a final removal order in absentia or otherwise, they're actually not included in the 450,000 caseload. Those are out of the system. There's a final removal order. Unless they file a motion to reopen later to come back in and the judge grants that, in absentia orders or any removal order is not included in that number.
All right. Given your background and your expertise, what percentage of folks who abscond are tried in their absence?
Sorry, sir, you're asking how many folks that don't
Fail to appear or tried in their
actually
absence?
get in absentia orders?
Yes.
I don't have that number for you. I just don't.
What other tools do you have other than trying someone in their absence? If there's a failure to honor a court date, what other tools do you have? You don't have a bench warrant. There's no presumption that is lodged against that. There's no evidentiary presumption, I would assume. You can't. I mean, can the judge consider the evidence of flight as some evidence of guilt or consciousness of wrongdoing if they don't show up?
No, what the judge will consider is whether the person actually is removable from the country under the law, and that's really the end of the inquiry. Once that is done, the removal order is issued, and then the person can be picked up at any time by ICE and deported.
Let me ask you one more question, and I'm going to let the Congresswoman follow up. I assume DOJ Inspector General is still Michael Horowitz?
It is.
I got to tell you, he's from where we sit, he's a pretty good balls and strikes caller. He's a fair guy. All my dealings with him, he's been kind of straight down the middle. So when I see that he has concluded that even as the number of judges increases, the disposition number of those judges decreases, that catches my attention, because it makes me think maybe something else is going on and it's not just more judges. I don't want to minimize. I mean, if that's the explanation, then that's the explanation. But when Mr. Horowitz says that may not be the full explanation, what else could be going on?
Mr. Chairman, I do think that the single biggest reason for the caseload is the shortage of judges over the last few years. I don't think that you can lose as many judges as we did at a time when enforcement was going up and not have that be a significant impact on the caseload and on wait times. We have taken a look at this issue repeatedly. We've kicked the tires. We've looked under the hood. We have tried to see what else is going on. One thing that we do hear quite a bit from all of our judges and from ICE trial attorneys as well is that the complexity of the law has gotten much more complex over the last 10 years. Cases that used to be fairly simple are now complicated. Let me give you an example. It used to be fairly straightforward to determine whether somebody is an aggravated felony under certain provisions. Because of Supreme Court precedent and other decisions, in many instances, the drug trafficking area is one, for example. It is actually much more complicated these days than it was 10 years ago to determine whether somebody is deportable as an aggravated felony for certain offenses. So that is one area that we have concluded, a judge may have spent, an hour on a case 10 years ago, and that same type of case now may take 4 hours because the law has gotten more complicated. We've taken a look at other issues as well, but we're convinced that that hiring the requisite number of judges is actually going to make a difference. And let me actually give you an example, or from actually within the agency, and that's the Board of Immigration Appeals. The BIA is doing very good decisions these days, very legally excellent decisions, providing guidance to the courts, and their caseload is stable. In fact, it has actually decreased slightly over the last few years. The lesson that we took from that is that the board has actually had, unlike the immigration courts, a balance between the incoming caseload and the adjudicators necessary to adjudicate that caseload. That's the lesson that we've drawn, and that's why hiring is such an important priority for us for the immigration courts, because we are convinced that that is how we will address this caseload.
Recognize the gentlelady from California.
Thank you, Mr. Chairman. Just a couple of follow-up questions, if you could get back to us on it if you don't know now. I would like to know what the failure to appear rate is on various categories. Looking at some of the data, it's very low. If individuals are represented by counsel, there are different outcomes if someone isn't. And so if you're able to make those distinctions, I think that would be helpful. I'd like to know, among the 30 who committed homicides or were charged with homicides, how many of them were Zedeas case releases or not? And among the, if they were Zedeas case releases, how many of them were Cubans? And with the change in status between the United States and Cuba, there's apt to be, the last time we looked at it, the vast majority of the Zedeas cases were Cubans. And if they are removable to Cuba because of our new relationship with Cuba, we're going to have a very different outlook in terms of the criminal issues and Zedeas. And then I just wanted to clarify for the chairman and others in terms of notice, because there's no requirement that the person receive actual notice. What you're looking at in the court is, was something mailed to the person? That person could have moved. He might never have lived there. We had a case a number of years ago of a legal permanent resident who failed to file the removal condition on her marriage, who was active duty Navy in a uniform, who was mailed a notice, never got it because she was deployed to Kuwait, and was found deportable in absentia because it was something she never heard of. So I think it's important to note that it's not like the criminal courts or the civil courts. You're not getting, a server handing you the notice. It's just in the mail, and you may or may not even know what's going on. Thank you, Mr. Chairman.
Thank the gentlelady. Would recognize the gentleman from Texas for any concluding remarks he may or may not have, and he is indicating that he is done. So this concludes today's hearing. I want to thank you for attending. I want to tell you again that the fact that folks may have been in and out or not able to come is no reflection of the seriousness with which they take this hearing. Fly-out days are always troublesome, but that's on us and not on you. You were here like you were supposed to be. Without objection, all members will have 5 legislative days to submit additional written questions for the witness or additional materials for the record. With that, we thank you for your testimony this morning and your willingness to answer our questions, and we will be adjourned.
Thank you, Mr. Chairman.